Today, August 12th, the petitioners face a defining task at the Supreme Court, drawing a clear legal battleground. There is no room left for missteps. Their advocates must arrive with a precise, disciplined strategy that persuades the bench that pension updation stands entirely apart from DA neutralization, separate in purpose, principle, and precedent.
Absolutely. The banks and DFS aren't going to do bank retirees any favors. They have, through their actions since MC Singla case arrived at the Supreme Court in 2016, IBA DFS primary concern has been the same. Not grief nor concern for the welfare of senior and super senior retirees, but self-preservation and the status quo.
Welcome to the deep dive. I'm Aditi Sharma and my co-host is Nisha Bhattacharya. If you hire a contractor to patch a leaky roof and they show up with bulldozers to tear down the whole house, you'd be pretty alarmed, right?
Oh yes, absolutely. I will be horrified.
I mean, totally hakka bakare jana.
Right, because words mean things. Patching a roof is routine maintenance. Rebuilding the house is a fundamental structural change. Today, our mission is to explore what happens when the highest court in the land confuses those two exact concepts.
And it's a huge issue.
It really is. We are diving into a critical legal briefing along with decades of historical settlement records, all prepared for an August 12, 2026 Supreme Court hearing.
Okay, what is the crux of the briefing and case?
This affects the statutory rights of millions of bank pensioners. So, okay, let's unpack this. During a previous hearing on July 22, the court metaphorically looked at a roof patch and a structural rebuild and said they were the exact same thing.
Right, they mistakenly equated 100% DA neutralization and DA merger with pension updation.
Exactly.
And while those terms sound similar because they all deal with inflation, legally blurring them potentially has disastrous implications for retirees' fundamental pension rights to updation.
Yes. The court likely got mixed up because both mechanisms involve the dearness allowance or DA, but functionally, I mean, they are entirely different universes. Getting this legal context exactly right is basically a matter of financial survival for bank retirees.
So, applying this to our own financial reality, is this confusing a standard cost of living adjustment with fundamentally rewriting your entire base salary?
Yes, exactly. And the distinction between the two is what forms our first two pillars from the sources. So, 100% DA neutralization is that standard cost of living adjustment. It just means an increase in the consumer price index is fully compensated through the dearness allowance.
Okay, right.
It, softens the blow of inflation on a fixed income.
Okay, so it's a buffer.
Yes, precisely. DA merger, on the other hand, well, that's the salary rewrite. This happens when a new pay scale is created by actively adding specific DA slabs directly into the basic pay.
And DA slabs are?
They are just the inflation brackets used to calculate pay, a wage, or a salary.
Got it. And that changes the math on everything going forward, right? It just permanently elevates the financial trajectory of that employee.
It absolutely does. But, and this is crucial, a DA merger only applies to working employees during a bipartite settlement.
Wait, what is that again?
That's the industry wide wage agreement negotiated every few years. It's an active structural change to the pay scale itself, not just a temporary buffer against inflation.
Hang on though. If the working employees are getting their entire pay structure upgraded and merged during these bipartite settlements, where do the retirees fit in? I mean, aren't the pensioners just getting left behind as the active workforce moves to a completely new financial baseline?
Well, that brings us to the third pillar, which is pension updation. When the pay scales of active working employees are revised through a DA merger, pension updation is the legal mechanism meant to redetermine the basic pensions of the previously retired employees.
So they match those new scales.
Exactly. It's designed specifically so bank retirees or pensioners aren't left behind.
Okay, so we have inflation buffering, active pay restructuring, and retroactive pension matching. But if you look at the actual history here, from the 7th settlement all the way to the pending 12th, there is a glaring double standard.
Oh, completely.
Right. For active employees, a DA merger happened every single time. But for the retirees, pension updation was never automatic. It was, actively disputed, deemed not applicable, or just dragged through endless court battles.
Yes, and the reason it constantly got stuck in court comes down to ambiguous interpretations by the banks. They often argued that providing basic inflation relief was enough to satisfy their obligations. But what's fascinating here is the ultimate legal anchor the petitioners are using to fight back.
Which is what?
Regulation 35.1, this was amended in November 2002, and it explicitly states that, quote, basic pension shall be updated.
Right. It doesn't say compensated for inflation.
No, it says updated. If the law only intended for basic inflation compensation, that 100% at DA neutralization we talked about, there would be absolutely no reason to explicitly mandate updating the basic pension itself.
Right? Because the law doesn't use words by accident.
Exactly. This language creates a separate, unavoidable legal mandate or contract for pension updation.
Even if you aren't a bank pensioner, this whole situation is a massive wake up call. It shows how standardizing legal definitions can literally make or break your retirement security. So, what does this all mean for the upcoming hearing?
Well, it means for today's August 12th hearing, the petitioner's counsel must use this specific history of bipartite settlements paired with the exact phrasing of Regulation 35.1 to argue the retiree's case. They can't afford another uninspiring performance similar to July 20 Tuck.
To demonstrate beyond all reasonable doubt, the petitioners must show the bench that these are three entirely separate and distinct concepts, different in purpose, in operation, in legal and financial consequence.
Right. To prove to the court that 100% DA neutralization, DA merger, and pension updation are three completely independent legal matters. You cannot legally substitute basic inflation relief for a mandated structural pension update.
It brings us back to the contractor. You can't let a court mistake a simple roof patch for a structural rebuild. And if the fate of millions of bank retirees depends on whether the bench can distinguish neutralization from merger, it raises a deeper worry. How could one misunderstood phrase jeopardize the dignity in old age that retirees spent a lifetime saving for?
Thank you for watching. Please subscribe and leave a comment for the algorithm. It ensures our podcast reaches people like you who needs to see this. Namaste.